interesting and young, bright mind from his school. Now he is going to talk about his Guru and the topic of Eternal Guru. I invite Advocate Divakar to speak about his Guru.
Honorable judges, ladies and gentlemen, a very good morning to all of you. Very interesting introduction given by Mr. Ramesh Ganapati. Garbage in is correct. The jury is still out as to whether it is garbage out. But that said, enough inputs have been given about which I am going to talk today. See, every lawyer has a starting point. Mine began under Mr. A. Mohan, as we call him as Mohan sir, my senior, my mentor.
Sir, to call the juniors, he'll be like, where's the petition? Sir, I'll give you today, sir. Tomorrow, sir. And that went on up to 2 weeks and anything more, I guess, because I had to research the prior arts all on my own again, which took a considerable time because my first assignment too, to know what a prior art is and to research and to take out the relevant prior art. I was very skeptical about my draft, not confident at all. One fine day when he was almost about to lose his patience, I said, sir, here it is. Sir, here it is. And I just ran out of the room. And I was waiting for a Friday too. So that sir will be busy on Saturday, Sunday. Even if he had a chance to see it on a Friday, he would have cooled down by now, by Monday. So I thought I would escape. And Monday morning I walked in. I was all full of fears. I even told my mama, please pray for me. I'm going to see my senior now with my draft on a patent matter, the two. The moment I walked in, he said, I was waiting for you. I lost all my confidence. I was like, gosh, I'm gone. But to my surprise, he stood up from his chair and he shook hands saying that, you've done a good job. I'm happy. Gone. I was like, I don't know how to react. For such a big man, for a novice like me, to get up and congratulate me, that's my senior. Yeah, and over the years, we've learned a lot of life lessons, I would say, in the first place. How to be a good person. He, as rightly Divakar said, he wouldn't teach you what is right, what is wrong. He will live and show others how it is to be. And he did that. And many of us, you would see, even in our presentation, we will have some semblance of the seniors. All of us juniors who were with Mr. Mohan, we still bear the semblance of his presentation. I have seen this with my own eyes till date. Yes. Now going back to Pasi, the association which was formed in 2011 with Mr. A. Mohan also, with many seniors initiating this big movement, I would say it was a movement back then because there wasn't any association for IP advocates until then. It was a good breakthrough for all the IP advocates to come together and put our minds and to think what is to be done next. It was a big initiative. This happened sometime in 2011. The society registered on 20th of April 2011 and it was formally launched as Justice Jyotimani, the retired judge of Madras High Court, on 26th, the 26th year, 26th April. It's about 15 years now. And this incident was widely covered in many print medias because it was quite sensational back then. There were about 13 members when it was started in 2011, and today we are a big family of more than 165 members. And of the 165 members, many of them are regular practitioners of IP. Until 2005 or 6, I would say, there were only handful of offices. Of course, my senior's office, Mr. Amon's office, V. Raghavan sir's office. Then we had Gladys Daniel's office, Satish Parasaran's office. There were only handful, and today we can see it's grown up into a big banyan tree, I would say, and there are more to come, I know. And this association has advocates throughout all South India states like Tamil Nadu, Pondicherry, Kerala, Andhra, Telangana and Karnataka. And yeah, we do meet on a regular basis to keep up the fire burning, to keep us going with lots of chats, discussions, everything. It's a regular custom for us to have a regular meeting all throughout. And yeah, we have many senior councils who are honorary members. The association honors all the senior councils with the honorary membership, a lifetime membership. And we have Satish Parasaran sir. We have Mr. our dear ARL sir, Sundaresan sir. We have Giridharan sir. We have A.K. Sriram sir. We have our president Bala sir. And this is Mr. Venkat Reddy Donta Reddy of Hyderabad. And this is, of course, yes, Mr. S. R. Rajagopal and many more. And 2025 had a marking in the beginning because in order to felicitate the effort of one of the members, our association decided to tie up with the launch of a book written by Adarsh Ramanujam. That was a grand success again. And 2026 was really close to my heart, I would say, because it started the A. Mohan IP lecture series. We had a thorough discussion on AI. And of course, many of us got to see Mr. A. Mohan through the eyes of Satish Kumar. As of today, we saw through Divakar's eyes. Sometime I'll get my chance to show him what he was. And yeah, we had a panel discussion, a very fruitful discussion, I would say. And Mr. P.S. Raman, he gave his address about Mr. A. Mohan. And the last year, AGM marked the launch of EPASI, the newsletter of EPASI, where we normally encourage the younger members in the bar to contribute to the e-letter by their articles, to make their presence marked. This is in a way to help the younger members in the bar. And the events, we had a heritage walk organized by the secretary with Mr. A.N.L. Raja and Mr. A.K. Sriram, who took us the entire IP bar. It was specifically for the IP bar. And we had the pleasure of knowing what is what about the High Court. And then IPASI partnered with VIT to have an international conference on emerging trends and IP rights, where many of our members of the association contributed their part. We had many members participating in the conference. And we also had a moot court competition in tie-up with VIT, where the Honorable Justice Anil Kumar Amurthy was there to judge the final winners and to give away the trophies. And many of our members again were part of the jury. And we're not, all work, no play makes Jack a dull boy. We're not dull boys. We are also very active in every respect. And yeah, credits to Kriya Law for organizing this. IPASI in association with Kriya Law had a pickleball tournament. We had this nice t-shirt. And yeah, this is all about our associations doing over the years. Thank you so much.
Now, the most exciting speech we all are going to hear from none other than Honorable Dr. Justice Anita Sumant on the topic of sports and IP. So why this topic? As highlighted by our President in the welcome address, World Intellectual Property Organization, in short we call it as WIPO, has a theme for every year. And this year the theme is Sports and IP. When we approached Honorable Dr. Justice Anita Sumant, her ladyship was so interested and excited to speak about this topic. And we all know that any topic we give to her ladyship, we see a student of law in her every time. One good quality we all should learn from her is that whenever there is an opportunity to learn, and whenever there is a new area to learn, and she will take it up and she will deliver in a better manner. Her ladyship, Dr. Justice Anita Sumant, the association her ladyship had with IP bar and IP law, I would like to highlight very few judgments. It will show the knowledge she had in the IP and the thirst sometime to go beyond the bar and to break the boundaries. When we are thinking about very few trademarks are being declared as well-known trademark in Chennai when it compares to Delhi High Court. Delhi High Court declares most of the trademarks are well-known trademarks. When there was a case for a trademark called Texmo, I think Bharat sir is here, so her ladyship was so bold enough to understand. In fact, at that time it was in 2017, and 2017 amendment was not even in place. And Bharat sir was arguing about the Paris Convention and Section 2ZZ. The ladyship was convinced and declared Texmo as a well-known trademark. In fact, that was one of the landmark judgments from our High Court when it comes to the well-known trademark. And when we talk about copyright, we all know what is Ilayaraja's case. Very recently, this High Court was in a fuss that there are two recent movies, Good, Bad and Ugly and Dude, wherein Ilayaraja's songs were used and there were litigation going on. Even for deciding that case, His Lordship Justice N. Senthil Kumar, if we read those judgments, Justice Anita Sumant's judgment, very detailed judgment, and it is like a reference. What kind of reference you want, whether what is the moral right for an author in a copyrighted work, what is a musical work, what is sound recording, how a sound recording is placed in a movie, if a song is not part of the movie, who has the right, each and every detail. Her ladyship is written in a very detailed manner. Even today, if you want to take a judgment to read and learn about copyright, when it comes to musical work or art, this sound recording work or movie, this particular judgment is like a Bible or a Gita. And when it comes to patent, the very serious issue whenever there is an examination process, the controller, sometimes they don't go beyond the bar and they stick to the guidelines and law. And there were cases, even in Delhi High Court, they were discussing about deemed abandonment. And when we highlighted to her ladyship, and ladyship wrote a very detailed judgment saying that when it is for a patent, the country like India, we need to encourage innovations and inventions. And procedures cannot stand in the way of inventions, innovations. And the controller has a power to condone the delay in a kind of smaller irregularities or technical issues. And she has granted time for filing the examination process, and patent went ahead for the grant process. So these are the very few judgments to talk about Her Ladyship Dr. Justice Anita Sumant. Now I would like to invite Dr. Justice Anita Sumant to speak in front of us. Welcome, Madam.
Ramesh has set the bar so high that I'm terrified I will fail. But as I was telling your President, Mr. Balasubramaniam, if at all there was anything of note that came when I was sitting in the bench hearing IP matters, it is all credit only to the bar, because as a subject it was a new subject for me. So every case was like a study circle, with the learned counsel teaching me every aspect of it and the ABCs of it. So all credit goes only to the bar. So good morning to all of you. Thank you very much for this invitation to deliver this edition of the memorial lecture in memory of Senior Advocate Mr. A.A. Mohan. Unfortunately, I did not have the privilege of knowing Mr. Mohan personally, but I was given a bio sketch, and I find from it that Arun here comes from a background with a legacy stretching to the 4th generation. Mr. Mohan's grandfather, Mr. Natesh Iyer, was a sub-judge at Tiruvannamalai prior to independence. His father, Mr. Arunachalam, was a practicing lawyer who specialized in the complex field of appellate work involving French law. And more importantly for the academic community, he founded the Constitutional Law Department in the Madras Law University in the late 1940s, continuing there till 1971 as a part-time professor. I am very happy to note a personal link here, in that I completed my master's in that department, though by that time it was expanded to become the Public International Law and Comparative Constitutional Law Department, 6 decades after he started it. Mr. Mohan himself was a son of the soil, an alumnus of Vivekananda College and Madras Law College, and after completing his master's in international law from the Madras University, he joined the barristers' offices of Devadasan and Sagar, moving to Delhi to head the intellectual property practice of Remfries and Sagar for a while. But the allure of Mylapore perhaps proved too much and too strong to resist. And in 92, he moved back, joining King and Partridge initially. Thereafter, realizing that IPR was his second love, he started Mohan Associates, now managed by his first love, Mrs. Brinda Mohan. The list of matters that he's appeared in and the range of issues he's argued are so wide and pervasive that I'm not going to even attempt to chronicle them here. Indeed, with this erudite an audience, I will be bringing coal to Newcastle if I were to make such an attempt. So I'll leave it at that. I see that he was a very, very generous senior, bringing perspective and value not just to the professional lives, but to the personal lives of all those juniors and colleagues who had the opportunity to join his office. And we saw that from the presentations of both Divakar and Subha. Well-travelled, a connoisseur of music, very religious, I understand from Divakar's statement that he learned the Hanuman Chalisa and various songs on the car journeys. And Balasubramaniam was telling me that any place that he travelled to, he would first seek out the temples there. A foodie, I can see that he lived life king size. A memorial lecture, friends, is a homage to an individual who has left an indelible imprint on those around them. It's a testament to their deep impact and influence, and a wonderful way of reminding oneself of what the person stood for. Continued presence that we feel till today. So today we remember Mr. Mohan fondly, and I want to thank the organizers and Arun Mohan yet again for this invitation to deliver the lecture. Now, having said that, I must question their wisdom in selecting me. I have not been a practitioner of intellectual property law during my avatar as a lawyer. I have, however, enjoyed my stints hearing intellectual law matters, and I've learned tremendously from them. That's on the one hand. Now, coming to sports, aside from running most unscientifically and playing shuttlecock and table tennis at a sub-amateur level, and winning perhaps my only sports award for lemon and spoon in the second standard, I really had no claim to fame as far as that world is concerned. So you may wonder, why on earth did she accept this invitation? Well, as Ramesh said, apart from the privilege of the invitation itself, I saw an opportunity to explore a subject that was new and trending, and that was my incentive. So here I am, and here goes. Sports and intellectual property is the theme of the World Intellectual Property Organization this year. By way of a backgrounder, the intersection of IPR and sports encompasses trademarks that are relevant in the context of team names, team jerseys, logos, and the like, copyrights that reside in the realm of songs, merchandise, podcasts, and patents that find their place in equipment design for, say, advanced helmet technology. Now, for the purposes of this lecture, I would like to address you in three parts: the past, the present, and the future. First, the past. When we think of litigation, it is our court that immediately comes to mind, at least to my mind. The red brick Indo-Sasanic arches, the weight of centuries-old precedent, the measured cadence of justice. But when we think of sport, we think of the roar of an expectant crowd, perhaps at Chepauk, the sudden hushed silence of a missed goal or a missed catch, and the visceral thrill of physical exertion. At first glance, these two appear to be opposites. One, the realm of the cerebral and the static, and the second, the field of the kinetic and the transient. However, as you all, specialists in IP law, know better than anyone, sport has over the years ceased to be a mere physical contest, evolving to a bundle of sophisticated, intangible assets. We are thus today poised on the intersection of these two worlds. Now let's trace the evolution of how a game played either in the sun or indoors became property, calling for protection in the courtrooms. Sport is about as ancient as man, and there are instances of sporting events over the centuries, both indoor and outdoor. Chariot racing originated in the Mycenaean era around the 13th century BC, and was well entrenched in ancient Greek, Egyptian, and Roman culture. It became popular in the Olympic Games when in Rome it was conducted in a stand called the Circus Maximus. There we had teams called the Reds, Whites, Blues, and Greens that competed in high-speed 7-lap races. Ancient Indian culture is also replete with instances of competitive sport. Indoor games like chess, ludo, snakes and ladders, and cards have had their early origins here. In fact, the Mahabharata narrates the instance of Chaturanga between the Pandavas and the Kauravas. And it also finds a description of a game akin to chess, though played with dice, which finds reference in an essay by Sir William Jones, which is a translation of the Bhavishya Purana. Wrestling, or Mallayuddha, as famous then as now, was replete with precise and structured movements. And there are instances of signature moves by Bhima and Jarasandha in the Bhagavata Purana, and by Hanuman, Sugriva, Vali in the Ramayana. These references are all detailed and graphic, citing instances of grappling, joint breaking, choking, and pressure point striking to indicate that wrestling matches were conducted scientifically and after a great deal of planning. That apart, games like cock and quail fighting were also well known, and we all know of Jallikattu, the traditional bull taming in Tamil Nadu, which has a long and hoary existence. The essence of a sporting event is a thrill of the sport itself, and while sport may contain the pleasure of intellectual stimulation, as in a friendly game of chess or tennis, other times it hones the competitive edge of players when there is an award or a trophy to be won. The Indian Olympic Association was formed in 1927 when intellectual property had yet to arrive as far as the world of sport is concerned. Under the British Copyright Act of 1911, sport was not considered a work. For a work to be protected, it required fixation and originality, whereas a match or a game was considered a transient spectacle, too unpredictable to be a dramatic work and too physical to be a literary work. In 1932, when India played its first test match at Lord's, the only IP involved then was the name of the Board of Control for Cricket in India that had been founded just 4 years earlier in 1928. The logic of that era was very simple. I'm not going to trouble you with a Latin phrase, but whoever owns the soil would own everything, up to the sky and down to the depths. Thus, if you owned the stadium, you controlled the right of entry, and that was that. At that time, one didn't sell broadcast rights, but one sold tickets. Value was counted in physical presence. The first radio broadcast of a cricket match in India occurred in the 1930s, and at that time, the law saw radio waves as news. The idea that a description of a game could be owned was a novelty in the law. The world's first live televised sporting event had been the 1936 Summer Olympics in Berlin, and in the US, it was on May 17, 1939, that an experimental NBC TV station licensed to New York telecast a game where the Princeton and Columbia baseball teams played. For those of you who are interested, Princeton won 2-1. There were only 400 households that had access to this match. There was a single camera that was placed between the second and third bases, and Variety magazine carried an article on that match. And the reporter said that the commentator was praying that every ball would be a home run because that was the only ball that single camera could catch. The first telecast of a sports event in India was, no surprise here, a cricket match. The first cricket match to be telecast live on Indian television occurred during the 66-67 West Indies tour of India. The Indian Prime Minister's 11 versus West Indies held at Firozshah Kotla in Delhi. Now that became history when it was broadcast live, though only viewers could watch it because of limited transmission infrastructure. The Copyright Act of 1957 was silent on any specificity qua the world of sport, but the 82 Asian Games marked some sort of a paradigm shift. This was the first time we had TV in color, and a match broadcast began then to be likened to a work under the Act. But the real tension was during the decades spanning the 50s to the 90s, and that was on account of state monopoly. Doordarshan was the sole arbiter of what we saw, and in those years, IP in sports was essentially a government entitlement. The courts rarely saw sports litigation simply because there was no competition. It was around then that the 1958 Trademarks Act began to be utilized by equipment manufacturers, and we have names like Sansperel Greenlands, which was in use since 1931 in the manufacture of cricket clothing and equipment, including bats, balls and other gear. The name is synonymous with the red balls used in Test cricket in India since 1994. Then there's BD Mahajan or BDM, famous for the English willow cricket bats and the hockey sticks. Recently, the US Supreme Court affirmed the Sixth Circuit by a 6-2 vote, finding that surface decorations on cheerleading uniforms can be identified as features having pictorial, graphic or sculptural qualities. The case is Star Athletica LLC versus Varsity Brands Incorporated, and the Supreme Court held, and I quote, "If those decorations were separated from uniforms and applied in another medium, they would qualify as two-dimensional works of art." So applying the test of separability or severability, the court concluded that while utilitarian sections of clothing are not protectable under IP law, surface decorations depicting team imagery were separable and therefore eligible for copyright protection. In all these instances, we see that the law protected the physical goods, not the event or the persona. Coming to copyright, the intersection of copyright with sports reveals in itself a myriad ways in which they are interconnected. The most important is music, which when paired with a game creates lasting memories. The earliest instance of a copyright deposit in the US was in 1867 for the song or the music Baseball Polka that was composed by one James Goodman. Apparently, and you can check this on the net, you have sheet music that has been composed for this music that he distributed in order to make the song popular. Another facet of copyright is sports photography, an instance where an image creates a lasting impression of a moment. It's not just the skill of the sports person at play, but the genius of the photographer who manages or perhaps is lucky enough to capture just the perfect moment to create magic. However, not everything that you see on the screen or field will be protected by copyright. For instance, we have end zone dances, or you have victory laps. I have fond memories of Ravi Shastri driving around the cricket field in the brand new Audi 100 when he was declared the man of the match in the 1986 Benson and Hedges. That is not protected by the law. Through all this development, the brand of the athlete and the rights in relation to the event itself were still in their infancy. Though the arena of sport had its fair share of larger-than-life heroes like Dhyan Chand and Sunil Gavaskar, their commercial value was largely untapped because the legal infrastructure for personality rights did not yet exist. We now come to a critical juncture in the legal history of sporting that rests on the shoulders of one case, Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal. The facts involve the BCCI's desire to sell telecast right for the 1993 Hero Cup to a private broadcaster, TWI. The government, however, claimed monopoly over the airwaves. The Supreme Court's ruling was a masterclass in the interplay between constitutional and IP laws, declaring that though airways are public property, the right to broadcast is an event which is a facet of Article 19(1)(a), covered by the freedom of right of speech and expression. This led to the 1994 amendment to the Copyright Act, which introduced Section 37 dealing with broadcast reproduction rights. There is a nuance here. Section 37 does not grant the copyright in a match, but it grants a special right to the broadcaster for a period of 25 years, signaling the birth of the media rights industry in India. Suddenly, people woke to the position that a signal, a media wave, was property that could be licensed, sub-licensed, and sued upon. This commercialization ran into a challenge in 2007 with the enactment of the Sports Broadcasting Signals Mandatory Sharing with Prasar Bharati Act. the Act mandated the sharing of signals which related to sporting events of public importance with national television, so that the public is guaranteed access to these events. But what is a sporting event of public importance was left undefined. I understand that the status quo continues today with an uneasy coexistence between the two worlds. There have also been instances where broadcasting companies have entered into settlement agreements with Doordarshan for sharing of broadcast rights for specific matches, with Doordarshan playing the match on a deferred live basis 1 hour later. Let's ease into the 2000s, the present. In 2008, IPL changed the scale of the game. It transformed sport from a tournament into a portfolio for intellectual property rights. In 2025, the IPL, valued at approximately $12 billion per the Forbes India 2025 report, is a brilliant illustration of slick IP bundling. This encompasses trademarks such as the names and the logos, trade dress, the specific color palettes of the team jerseys, and broadcasting rights, which are split between television and digital media. Statistics show that in the 2023 to 2027 cycle of the IPL, Viacom 18 and Disney Star have divided between them profits amounting to nearly 48,000 crore rupees. As you would all know, this brought home the era of John Doe or Ashok Kumar orders. And the Delhi High Court and our court are privy to a regular flow of preemptive injunctions allowing IP owners to block hundreds of pirate websites before even the first ball is bowled. It's a controversial but necessary tool to protect the massive investments made by broadcasters. This millennium also sees the shift to accommodate not just the signal but also the star. In 2003, the Delhi High Court in ICC Development International Limited versus RV Enterprises dealt with personality rights. It held that personality rights vests in those persons who have attained the status of a celebrity. It clarified that those rights cannot be owned by an organizer like the ICC, as they inhere only on an individual. Think about these implications. When MS Dhoni trademarks his helicopter shot imagery, or when Virat Kohli executes a multi-crore brand endorsement agreement, they are asserting a common law right of publicity. And we have seen instances worldwide where a sportsman's signature pose has been protected as a motion mark or a logo when they choose to monetize it and use it on branded merchandise. For instance, Usain Bolt's lightning bolt or Michael Jordan's Jumpman silver, which signals a mid-air slam dunk, or you have Gareth Bale's 11 of Hearts goal celebration. The list goes on and on. These trademarks are all associated with the individual and have become very iconic, calling for protection. In India, we don't have a publicity rights or an image rights act. And instead, we weave this into three strands. One is Article 21, the right to privacy as affirmed in Puttaswamy's case. 29 of the Trademarks Act, which protects against association and dilution. And the law of passing off, which protects the goodwill attached to a face or a name. We also have recent judgments in the case of celebrities like Amitabh Bachchan, Anil Kapoor and Sunil Gavaskar, which I understand is still pending, who had approached the courts for protection against the exploitation of their personality rights, and those judgments could well give us a cue as to how to approach this across the board, including for athletes and sportspersons. Coming to a copyright in an event, the Delhi High Court in Aquate Internet Services versus Star India dealt with Star India and the BCCI, claiming paramount rights over the entire bouquet of information emanating from cricket events, including mobile rights and mobile activation rights. A third party in that case had disseminated match information through live scorecards, match updates and score alerts on SMS and mobile value-added services. And according to the plaintiffs, that was unjustified, unauthorized, and amounted to commercial misappropriation. The division bench, Justice Ravindra Bhatt authored that judgment, held that the injunction it sought for could not be granted, as injunction could only secure an object protected by the law, whereas in that case, the information that was disseminated was not protected information. I'll just quote a couple of sentences from their decision. They say, doing what the plaintiff invites this court to do would be to keep away from the public, match facts and information which are not protectable in any manner known to law. Such an injunction would tend to insidiously and in a creeping manner denude the fundamental right to free speech and dissemination of topical information to members of the public. So it was rejected on all grounds. Now we come to the future. The future is undoubtedly exciting with the rise of various cutting-edge concepts. You've got digital twins, AI-generated highlights, esports, and fantasy sports. There are 3 judgments that have been rendered in the context of fantasy sports by the Punjab and Haryana, Bombay and Rajasthan High Courts in Varun Gambar's case, Gurdeep Singh Sachar's case, and Chandresh Sankhala's case. And these have decided that these sports are games of skill, and the Supreme Court has confirmed that position in one case. But some questions remain, and current debates would center around whether a player statistic constitutes IP, who owns live data, and if a fantasy app uses a live feed of scores, would it constitute infringement of a database right? I'll leave these questions perhaps to be answered in part by the panel to follow, and for the rest of it, for the march of law to establish in the course of time. India does not have a database act, and our courts presently use the sweat of the brow doctrine. Before I close, I'll touch upon 1 or 2 recent cases. The first touches on the concept of ambush marketing. A claim of ambush marketing is where an entity which is a non-sponsor of an event, non-official sponsor of an event, promotes its merchandise by relating it to a particular tournament or team without having paid for that privilege. In such situations, the courts have said that control can be exercised only with registration and protection of all the intellectual property associated with that event. This concept was discussed in 1992 decision in National Hockey League versus Pepsi Cola Canada, and recently in Royal Challengers Sports Private Limited versus Uber India Systems Private Limited and others. Royal Challengers had approached court challenging the use of its brand by a non-sponsor, but the claim was rejected since the court held that it was only light-hearted banter which did not constitute infringement or disparagement, as it lacked malice. The threshold for ambush marketing thus appears to be placed quite high in order to be able to reach it. As we look back over the last 100 years, we see a move from the stadium to the screen and now to the server. Your duty as specialists in this field is to ensure that the law keeps pace with technology, and also to ensure that you keep pace with technology in order that you are able to interpret the law in a meaningful way. My duty as a speaker is, however, to leave you with a larger and a more compelling thought. When I started researching this subject, I found a glut of materials available on sports and intellectual property. In fact, the WIPO has itself released a primer on this very subject. Every article, without exception, proceeds on the thinking that sports is an industry. one that has a huge impact on the economy, and strategies must be developed by us all to sustain and develop it through IP rights. Certainly, that should be done, and we are all here to pursue that as professionals. But there is an alternate path that cannot be lost sight of. Traditionally, participation in a sport should equally be one of enjoyment and community building. Sociology of sports today is a subject that is gaining ground, one that recognizes the profound connection between sports and the society where sports exists, the influence of society on sports and the power dynamics therein. However, over the 19th century and particularly the last 50 years, sport has moved from being a friendly neighborhood reality to one that is institutionalized and formalized. The transition of sport from an accessible form of entertainment to serious business has created a world where entire economies hinge on this and on the outcomes. As more money flows into the arena, the cost of entry rises. When a fun game becomes an intellectual property portfolio, we risk creating a paywalled culture where many stand excluded. Many can no longer afford the price of a digital subscription, a stadium ticket, or in many cases, even sports gear. I want to warn against the commodification of that roar at Chepauk. That cannot be a social cost, and we as responsible professionals must ponder upon that. I remember when Justice Mahadevan was sitting in Madras, he wrote a judgment where he said we must have an act, some enactment to look into streamlining of the sports industry in Tamil Nadu, in India, at least in Tamil Nadu. Finally, today, we have the National Sports Governance Act 2025. That has introduced a section which deals with transparency and IP audit requirement for all national sports federations. This is the first time that I have seen where governance has been linked with the management of sporting bodies, and it's about time that we did that, because we see the movement of sports, the development of sports in the country being halted, being stymied by the litigation that flows. Volleyball, football, name it. They are all before the courts, and it's all a power struggle. I find that many sections in the Act are yet to be notified, and though it is early days, I fondly hope that this piece of legislation helps us to pause and realize that we should allow intellectual property to become a bridge rather than a wall, so that we don't risk losing the shared cultural heritage that defines us. The importance of us pausing and thinking of this cannot be overstated. Sport belongs to the person on the street as much as it does to the broadcaster in the boardroom or those of us who sit in the pavilion seats watching matches. Intellectual property must be a bridge to innovation and not a barrier to shared experience. I am confident that together we will find a way to make both worlds happily coexist. I will conclude now with a wish that I hope will balance what I have said thus far. May your arguments be as precise as a Dhoni stump out, and your precedents be as enduring as the red walls of our heritage court. Thank you.
Thank you, Lordship. As we expected, it was a brilliant speech. And before we move on to the panel discussion, so we can have a short tea break. So we are expecting the honorable judges in very few minutes. President sir, we'll have a short tea break. Just 5 minutes.
போனது ரைட்டா